This is the Fifth Court of Appeals with Justice Peterson presiding. Justice, I believe we're ready to go.
Okay, great. Thank you so much. I want to thank all the parties for accommodating us here. Based on the inclement weather, we've kind of last minute gone back to something we did a year ago, but we have a new clerk, so we're kind of getting back up and running at the last minute here. So we apologize for any inconvenience or any issues we have with the reacquainting ourselves with the technology, but we sure are happy that all of you all are here. We want to welcome you to the Fifth Court of Appeals. My name is Bill Peterson. I'm honored to serve with my colleagues, Justice Emily Miskell and Justice Ken Mulberg. These Zoom oral arguments are going to be live streamed on our YouTube page that you can access through the Fifth Court of Appeals page. At some point, there's going to be a screen. I can't see it right now. It may be the Fifth Court of Appeals screen that will have a timer. Both sides, you get 20 minutes for the appellant, 20 minutes for the appellee, and then the appellant gets 5-minute rebuttal. You don't have to reserve any time. This is the only official, there it is. We don't need it to start yet, but that's the timer, great. This is the only official recording of this proceeding. And we look forward to you all helping us get the law right in this case. I'll go ahead and call the case, make sure we're talking about the right thing. This is Anchora Insurance Services, LLC versus Texas Green Star Holdings, LLC, case number 05-22-0833-CV. Is everybody here on the right case?
Yes.
Yes.
Excellent, excellent. Thank you so much. Are both sides present and ready?
Yes, Your Honor.
Yes, Your Honor.
Yes.
Excellent, excellent. If you could do us the courtesy of when you begin your remarks, if you could identify yourself and your client, you may proceed whenever you all are prepared.
Thank you, panel. I appreciate everyone's flexibility. I hope everyone can hear me all right, but we do appreciate everybody's accommodation. We had some travel issues getting up there to Dallas, so glad to be here. Joshua Nelson Archer, here with my co-counsel, Ms. Catherine Gross, on behalf of Appellant Anchora Insurance Services. This case arises out of primarily a first-party insurance dispute related to property insurance policy that was attained by appellee Texas Green Star Holding. Upon being sued, my client filed a special appearance in the trial court back in December 2021. The special appearance was heard in the trial court in July 2022, and on August 1st, 2022, the trial court issued an order denying the special appearance. This appeal has ensued, and that's why we are here today. The background facts of this case are a little tedious, but it takes a little bit of understanding of those background facts in order to understand how to apply the law in this case. My client, Anchora Insurance Services, formed in October 2012 in South Carolina. Anchora and its representatives operate as insurance agents for commercial businesses seeking general liability, real property, personal property, and casualty insurance. In approximately December 2020, a financial services firm also based in South Carolina, 5 on 50, reached out to Aaron Smith, the owner of Anchora, who was also in South Carolina, and asked if Anchora could help a client of 5 on 50 find general liability and property insurance so that that client could get a loan from the U.S. Department of Agriculture. Anchora had no involvement in the soliciting of appellee's business in Texas and was not aware of the existence of appellee until 5 on 50 reached out to Anchora. Additionally, 5 on 50 connected Anchora with a banker located in Florida who was assisting appellee obtain the loan from the USDA. The banker informed Anchora what general liability and property coverage limits were needed by appellee to obtain the loan. Prior to a client of Anchora moving from South Carolina to Texas, a few months before this introduction in the fall of 2020, Anchora did not have a license to sell insurance in the state of Texas. The intent behind obtaining a license to sell insurance in Texas was simply to comply with Texas law as a retail non-resident agent. Anchora does not have a written contract with Green Star in Texas, and Anchora was not compensated for its work by Texas Green Star, but by the insurance companies with whom the insurance was placed. To obtain coverage needed by Texas Green Star, Anchora reached out to obtain quotes from a third-party company, Risk Placement Services. Risk Placement Services, or RPS, is a wholesale insurance intermediary that has direct access to insurance companies and served as a conduit between Anchora and the insurance companies where the appellee placed coverage. Appellant originally contacted RPS's office in Georgia, but were referred to an RPS office in Dallas, Texas. Anchora's contract with RPS is with RPS in Rolling Meadow, Illinois, not Texas. Once Green Star received their insurance options, they requested that the premiums be split into a payment plan. As such, Anchora reached out and obtained a premium finance quote from yet another company, IPFS, wherein IPFS offered appellee terms for down payments and installments of the premiums due. Upon getting the premium payment plan, Texas Green Star sent a check to Anchora for the initial deposit down payment dictated by IPFS and the insurers who agreed on the premium payments. Upon receipt of that check from Green Star, Anchora deposited the check in its South Carolina bank. It received its 10% commission and sent the remainder of the funds to RPS for payment. The totality of Anchora and Texas Green Star's involvement was approximately 12 days of interaction. Representatives of Anchora spoke directly to Texas Green Star via telephone from its office in South Carolina approximately 3 times. Anchora and appellee exchanged less than 20 emails regarding the placement of the insurance. Representatives of Anchora did not have any in-person meetings with appellee at any time. Anchora did not physically mail any tangible documents to appellee in Texas. Anchora personnel never traveled to Texas in relation to the services provided. All services provided to Texas Green Star by Anchora took place by Anchora in South Carolina. All of appellant's potential witnesses reside in South Carolina, and any evidence relating to the work done by Anchora are in South Carolina. Anchora does not own and has never owned a Texas bank account. Anchora has never had a postal box in Texas. Anchora does not own any real property in Texas, has no property in Texas, and pays no taxes in Texas. Anchora has never had a registered agent for service of process in Texas. Anchora has never performed any services within the state of Texas for other clients. Anchora has never had any employees based in Texas. Anchora has never had any appellees travel to Texas for business. Anchora has never recruited an employee in Texas. Anchora has never marketed its services in Texas. Appellant has only 2 clients, not including Green Star, with any connection whatsoever in Texas. The first client is an entity that is headquartered in South Carolina, along with Anchora, that owns some property in Texas. The second client that Anchora works with in Texas is one that lived in South Carolina and subsequently moved to Texas. All services provided for those clients were done by Anchora in South Carolina. In the only 2 years appellant had any clients with connections in the state of Texas, years 2020 and 2021, the annual revenue received from those clients was less than 5%. Specifically, in 2020, Anchora received approximately 0.2% of its revenue from a client located in Texas. In 2021, once Appellee was a client, that number jumped to approximately 4% of its annual revenue. That's the background for it. Now for the law as it applies. Anchora's special assessment should have been granted because there is no Texas specific jurisdiction over it. Anchora's contacts with Texas were random, isolated, or fortuitous rather than purposeful. Anchora's telephone and email communications with
how can you say that your contacts with Texas were random, fortuitous when you reached out to Texas to get a license to do this specific deal?
Yes, the acquisition of the license it's mandatory for insurance agents that write into the state of Texas.
It's a privilege of conducting activities in Texas.
And
right?
it's more of a hammer. If you do not have a license, then there are certain penalties that can be assessed.
So and the privilege is you avoid those penalties, right?
Yes, that's the privilege that you get out of it, is being subject to fairly draconian penalties. However, the importance of that is that the license to sell insurance services in Texas is a non-factor. Holding a license to sell insurance is not sufficient to establish general jurisdiction. I'm
glad you brought that up, because we're not talking about general. Because I'm glad you said it that way, because would it, however, have some effect over a finding of specific jurisdiction?
We don't believe so. In the case law on that, there's not a ton of it, to be candid with the court. However, there are two cases that are fairly well on point. The court in International Turbine Services versus Lovett, that's a 1994 case out of the Fort Worth Court of Appeals, found no personal jurisdiction where defendants with a non-resident license to sell insurance in Texas did so only sporadically and with minimum business in the state.
Weren't both of those cases, don't both of those cases relate to general jurisdiction and are therefore distinguishable?
Well, they are somewhat distinguishable, but the availment of my client to Texas was sporadic and intermittent. It was not a big part of their business model. The license to sell insurance does not confer that general jurisdiction without.
But you're using general jurisdiction language. Imagine if, let's assume for the sake of the argument that we agree that your client is not generally present in the state of Texas. Explain to me why we shouldn't find specific jurisdiction, since this lawsuit relates specifically to the business for which your client purposely availed itself of the privilege of conducting business activities in the state of Texas.
The license in and of itself is insufficient without coupled.
Well, hold on. Let me pause you there, because I don't think that's the question I heard him ask. I think the question I heard him ask was, your client agreed to do this deal with a Texas person, specifically reached out to Texas and got a Texas license to do this Texas deal. Why can't your client be sued in Texas for this Texas deal that your client specifically got a Texas license for? In International Turbine, the deal they were being sued on was not the deal they got a Texas license for. So specifically, this deal was about this license in this state. So explain how that wouldn't be a specific jurisdiction.
Well, the license was obtained before the interaction with Texas Green Star in this case. So the license wasn't acquired specifically.
But they are being sued over the deal that was done under the Texas license. Is that right?
They are being sued for this conduct, which my client does have a license in Texas to use. Am I answering the question you're asking?
You're now understanding my question. So answer, why wouldn't that subject them to specific personal jurisdiction in Texas?
Because the sole involvement of having the license is not sufficient. So
right. We agree. Just having a license is not sufficient, but why isn't having a license plus doing a deal under that license not sufficient?
The license plus the acquisition of the client, who my client did not reach out, did not reach into the state of Texas. This client was brought to my client, who, while working in South Carolina with all of his firm's resources in South Carolina, was able to procure an insurance policy that the appellee had requested. So that's the distinction. Our client's work was in South Carolina procuring insurance. Our acts were not in Texas and weren't availing ourselves to Texas.
I did have one other question, which you said in your brief that there was no contract with Green Star because there was no consideration, and Anchora couldn't be sued if they didn't place the insurance. But so you're alleging there was no bilateral contract, but it sounds like there could have been a unilateral contract, right? Where the performance is the consideration. You know, if I find you the deal, then you owe me some payment for it, right?
Well, that's not the way this was structured. Texas Green Star doesn't pay or didn't pay my client. What happened was, whenever the insurance is placed, then the insurer with whom the policy is placed, then they pay the commission. The commission is not paid directly by Texas Green Star.
Well, so you got some of Texas Green Star's money through an intermediary, so to speak.
Well, no, we got money from the insurers that placed the policy for Texas Green Star.
And where did they get the money?
They got the money from Texas Green Star.
Okay, thank you.
Right. So that would be akin to a parts supplier, you know, getting their money from a customer, you know, if they actually bought it from General Motors, because General Motors supplied the money to them. So that's that distinction. I think the case that is fairly illuminating on this is the IRA Resources versus Griego case. That's a case where a California company helped a Texas couple do a rollover IRA so that they could self-direct that money into a what seems like an antiquated idea, customer-owned coin-operated telephones. And that was in 2001, as recent as 2001, which is somewhat surprising. In order to fund the investment, the Griegos rolled their IRA into a self-directed IRA that was administered by IRA Resources. IRA Resources opened the account, took a fee for opening the account, administered the IRA, and then issued monthly statements, reported tax information on this IRA to the IRS. The Supreme Court looked at that case and found that Texas courts did not have specific jurisdiction over IRA Resource because its contacts with Texas, both before and after the IRA at issue was opened, were random, isolated, or fortuitous. Specifically, IRA Resources did not market or solicit in Texas, did not send forms to Texas, did not negotiate terms of the contract in Texas, and never had heard of the Griegos before accepting the application. Further, the court found that contracting with and accepting a fee from a Texas resident for services performed in California was insufficient to satisfy the minimum contacts test. Additionally, the court looked at the factors of that IRA Resources had no bank account or no postal box in Texas. None of its employees ever traveled to Texas for business, and that had never instigated or authorized any significant action in Texas. All of the actions under the contract occurred in California. The court found
I'm sorry to interrupt. In the IRA case, did the defendant who was contesting personal jurisdiction in the state of Texas acquire a license in order to engage in that transaction?
I don't want to misrepresent to the court. I don't know the answer to that.
But would you agree that would be a meaningful distinction?
I don't know that it would, in that having a license in the state of Texas does not all of a sudden open every claim up to some sort of jurisdictional issue. If the interaction in the state of Texas is fortuitous, remote, random, that sort of thing, then it wouldn't. But in this case, what's before the court today, the Anchora and appellee's relationship is even more remote than the relationship was in the IRA resources matter. Our company, a South Carolina entity, was approached by another South Carolina entity to initiate this relationship. For the next 12 days, the party acted.
So let me pause you for a second because we're short on time, but I'm looking at IRA versus Grego, and it says the first element of purposeful availment is that a defendant can only trigger specific jurisdiction through its own conduct. So in IRA resources was passively reached out to, but you're saying your client, through its own conduct, reached out to the Forum of Texas. One would think that applying for and receiving a Texas license might put one on notice that one is subject to Texas regulations on that deal. So can you explain how that's not purposeful availment in a way that distinguishes IRA resources?
The IRA resources case is actually more conductive than what our relationship is. We were reached out to, as I said, by a third party in South Carolina for the procurement of this. We did have a license in Texas so that writing insurance or assisting a customer in Texas in getting insurance was not in violation of Texas law, exposing our client to significant penalties.
So your client viewed the license as a meaningless formality that just avoided getting in trouble, but didn't impose any affirmative obligations.
No, my client viewed it as an administrative requirement in order to be able to comply with the law and be able to place insurance to Texas customers.
Any other questions? Thank you so much. All right. Councilor Appellee, whenever you're prepared, you may proceed.
Thank you. Good afternoon. My name is Samuel Ackles. Myself, along with our firm, represent the appellee in this case, Texas Green Star LLC. As a brief background, Texas Green Star is a Texas-based minority-owned startup company. It operates in Sanger, Texas, where it grows vegetables and greens for various retailers. It involves 322 acres of land and over 1 million square feet of greenhouse coverage. Texas Green Star, when it was beginning its operation in March of 2020, needed to obtain a $15 million USDA loan to fund its venture and build its infrastructure. They sought an agent and a broker to help them obtain insurance coverage to insure the property, insure their investment, insure their equipment located in Texas, and it was a requirement under the USDA loan. This is how Texas Green Star met Anchora and Mr. Smith. Mr. Smith and Anchora became Texas Green Star's agent to procure and obtain this insurance coverage. They acted as Texas Green Star's agents, and Texas Green Star's claims in this lawsuit arise out of their conduct, the conduct of the appellant, Anchora, during their time as our agent and their numerous breaches, which we alleged in our petition. The case is on appeal, really only presents two issues in front of this tribunal. The first one is whether or not Anchora has established minimum contacts in Texas to justify assumption of specific jurisdiction on this case. And the second is whether the assumption does not deprive them of federal due process protections. It's clear, and our presentation today, I think, will show the trial court was correct in assuming jurisdiction, and there's been no violation of federal due process protections. Anchora is a company out of South Carolina. However, it participated in a business relationship in Texas for the specific purpose of seeking profit. It obtained profit from a Texas residence. It availed itself of the privileges of Texas law, and the privileges and protections of being a licensed non-resident agent in Texas. We've cited Luciano versus sprayfoampolymers.com as a Texas Supreme Court case from 2021 showing that established minimum contacts can come through specific jurisdiction. I'm sure this court is well aware of that case. Let's list out the specific personal availment minimum contacts of Anchora in this specific case. The most obvious and clear one, Anchora got a license specifically in Texas for the intent and purpose of selling, of gathering insurance, becoming the agent of our client, and obtaining insurance coverage with our client on this specific case. This was notated in the deposition of Aaron Smith, which is attached. It's in the clerk's record on page 234 and admitted again on page 238. The copies of the insurance for Anchora and Aaron Smith, its sole owner, are in the clerk's record on pages 423, 425, and 427.
So let me ask you a question, because right now you're talking about the relationship between the two of them. In your brief, you kind of go out of your way to say that Anchora had a fiduciary relationship with Texas Green Star. I didn't quite understand, what does that have to do with our analysis here? Is that relevant in any way to the personal jurisdiction issue?
It is, Your Honor. Thank you for that question. The long arm statute, one of the ways to obtain jurisdiction is if tortious conduct happened in Texas, number one. And so a breach of a fiduciary duty, a breach of the Texas Insurance Code, a misrepresentation based on their duties to us, we would argue that occurred and caused damage in Texas, trigger the long arm statute, as well as conducting business, for one. Secondly, Judge, the numerous cases that are cited, and a key distinguishing factor from the cases that are cited by the appellant is that the fact that they became our agent and they represented to the outside world that they were the agent of Texas Green Star, and they binded coverage, insurance coverage as our agent, creates additional contacts with the state of Texas. The creation of the fiduciary responsibility between an agent and an individual shows purposeful, intentional conduct by Anchora creating this relationship, and shows their conduct to the state and the forum in specific.
So let me tie that to the question that I was asking Anchora, which is they're sort of denying that they had any contractual relationship with Texas Green Star. I asked, did they have a unilateral contractual arrangement? No contractual arrangement at all. The only relationship that Anchora has is with its insurers that it places policies with. Can you respond with what type of relationship your client had with Anchora?
Yes, this was a contractual relationship. There's problems in the deposition of playing with words and what makes an agreement, what constitutes an agreement or a contractual relationship. The relationship was Anchora would operate as my client's agent. They would seek out line coverage that would be acceptable to cover the needs of the loan. And once placed, my client would pay Anchora directly, which we did. We wrote a check directly to Anchora from my client. They deposited it in their account and took their fee and then forwarded it to the insurance companies. The fact that there is a contract between Texas Green Star and Anchora is admitted by Aaron Smith in his deposition on clerk's record page 199 and on clerk's record page 296 through 298. They have different words. Oh, they were our insured. Oh, these are actually our assignments. What it is, Your Honor, is a fiduciary relationship and a contract that these individuals would operate as our agent. And if they obtained this coverage, they would get a commission.
Mr. Ackles, let me ask you a question. I'm a little bit confused. I believe Mr. Archer, Mr. Nelson, had indicated that your client never paid his client anything. Is that just inaccurate?
False. It's false, Your Honor. The check, a copy of the check is included in the clerk's record. Let me see if I can get you the notation for that. It's on clerk's record.
I believe go ahead.
I'm
go
sorry.
Ahead.
I
Clerk's
believe
record.
Page 465. The specifics can also be found in the depositions about clerk's record 306, 300 to 304. The way that they are compensated in this case is that Anchora invoices Texas Green Star directly. Texas Green Star writes a check to Anchora. They then take the check, deposit it in their account, and then they pay out from there. They bring up some independent contract. I'm not so I guess it's their agreement with independent individuals about how this check gets broken up, but we wrote the check to Anchora. They profited from us, which is, by the way, why they did all that they did. They had over 100 contacts with Texas individuals. Ryan Pike from RPS was out of the Dallas branch. They knew their contract with RPS was going to be obtaining insurance for Texas property and Texas equipment. Their calls with Ryan Pike out of RPS were out of the Dallas branch. Now, I would actually argue to the court that the contract of this bank in Florida, or the contract between them and RPS being somewhere in Illinois, that's random. That's isolated. That's not continuous. I would agree on those if they were being sued in Illinois. However, they're being sued in Texas for the calls and representations they made in Texas to multiple people in Texas. And the record indicates they had over 100 contacts, emails or phone calls between themselves and a Texas resident, Ryan Pike or Texas Green Star. And those correspondence contained the misrepresentations that make the basis of this case and the binding of insurance. The nature and quality of the contacts, as well as whether or not it was reasonable they could be sued in Texas or foreseeable, are important factors for this court. Searcy versus Perix, I think it's Perix Resolution Inc. from the Texas Supreme Court in 2016. We cited in our brief. It's a continued unilateral action by Anchora. No other action by any other parties. They obtained the license for this case. They needed additional help to get additional coverage on their surplus lines. They contacted Ryan Pike from RPS. They worked with him many times in Texas. They spoke with us as our agent. They represented on the ACORD application that they were our agent out of Texas. They knew the property that was going to be insured was located in Texas. They knew what we needed to get the coverage we needed. They failed. They should be sued in Texas. They knew about this, and they did everything that they did for the specific purpose of getting profit and finance from a Texas resident, us.
Well, let me ask, so how do you distinguish IRA resources? Because the contacts in IRA resources are arguably similar to this case, and the court held doing paperwork in Texas, accepting payment in Texas, communications with someone in Texas were not enough for specific personal jurisdiction.
Yes, Your Honor. Are you speaking of IRA resources versus Griego? I think there's two IRA resources cases.
Yes, the one I was looking at was 2007 Texas Supreme Court.
Thank you, Judge. Yes, there's multiple distinguishing factors in this case, Your Honor. The first and foremost being the one you pointed out yourself, Justice Miskell, the one that there was no interaction or application for a license or specific conduct by IRA resources in order to obtain the case. And in IRA resources, there was no evidence that IRA resources did anything. All of the contacts were done by the Texas resident. Here, it's way different. First of all, in IRA resources, they didn't even have evidence of any contact at all, other than, I don't think they had any correspondence at all other than the mailing of these kind of bank statements. I believe in that case, the IRA was the individuals in Texas did all the investing in it. It was they were just kind of a holding company assisting them with the investment. In our case here, Anchora contracted with a Texas resident. They negotiated it with the Texas resident. They negotiated with RPS. They held themselves out to other companies that they were going to do that. They, unlike in IRA resources, appellant applied with their own action to become a licensed individual to sell. They've since renewed. They continue to operate in Texas, and they did it for the specific purposes of profiting in Texas. And there is quite a bit of correspondence on this case, Your Honor. Unlike in IRA resources, the entirety of the correspondence is between us and them, a Texas resident and a South Carolina non-resident, which is our agent. And there is, like I stated earlier, they've admitted to over 100 instances of correspondence on this case, including the key, which was the binding of the insurance. So I think I will note they have a case that says maybe just emails and calls aren't enough, or a case that says maybe a license isn't enough for jurisdiction. They don't have a case that says if you have a combination of all these factors, it's not enough. And we have a combination of all these things. And I think that definitely distinguishes itself.
Well, I want to ask a little bit about fair play as well, because looking at everything overall, it seems like your client was availing himself of South Carolina quite a bit. He's the one that chose to, or I'm sorry, the entity is the one that chose to seek out a financing company in South Carolina, to ask the financing company to find an insurance agent in South Carolina. Your client knew that Anchora did not have any offices in Texas. If your client had wanted Texas insurance, why was your client availing itself of the South Carolina forum in all of these transactions?
Well, Your Honor, our client was in search of an agent that could sell insurance in Texas. One presented itself that so happened to be located in South Carolina. I would point out to the court that the conduct of my client is technically irrelevant. The question is, what are the acts of Anchora?
But I mean, that is what I'm asking about, because Anchora is saying, hey, we're just sitting over here minding our own business in South Carolina. Your client was the one that brought us into this deal. We live in South Carolina, our offices, our employees, our money, everything's here. Your client's the one that's hauling us out to Texas.
Right. Well, I think, Judge, a compelling case on that specific point of them complaining foul play is the Nogle case, which we cited. And it also links to I think it's the Machana East Living versus Holton, Texas Supreme Court case. When you look at this, non-state residents can do things to avoid Texas. If they feel like we were being unfair by reaching out to them, they could have done things to not avail themselves of Texas. They could have said, we don't have a license, we're not going to get one. They could have said, don't pay us, pay RPS. They could have done many things to avoid the state of Texas, but they didn't do that. They purposely availed themselves of Texas and their conduct. In fact, they've presented no evidence, none, that when Texas Green Star approached them to be their agent, that they said, we can't do that. They could have said, it's too much of a burden for us to go get this license. They didn't. It wasn't a burden. And if they want to come in here and say it's unfair, they made 100 phone calls and emails to multiple Texas residents, us and RPS. They knew the coverage was going to be Texas property that was covered. They knew that it was going to be Texas equipment. They knew that we were located in Texas. None of this presented a difficulty for them to go and get a license so they could get a profit. But somehow it's such an inconvenience that they got sued on the case when they messed up, when they came here to do it. That's not an inconvenience. They have said there's numerous witnesses. They haven't listed one other than their own client who sat for his deposition on Zoom already on this specific special appearance. They've purported discovery in this case. They have Texas lawyers representing them. They've engaged in special appearances. They have not notated one thing that inconveniences them more than any other non-resident. We've cited the Moncrief oil case, Judge, and I'm sure we're all aware of that case, but it states if we're looking at fair play when it comes to federal due process protections, it states that everyone who's a non-resident is inconvenienced somehow. But Anchora has failed to explain to this court or to anyone how their inconvenience is any greater than any non-resident. It's every non-resident has the same inconvenience they have. And I would say it's a much greater inconvenience to go to South Carolina, which is, by the way, the second level of the test. What is Texas's interests? What is the forum state's interest in litigating this case in Texas? This case arises out of a breach of agency out of Texas, an insurance, Texas violation of the Texas insurance code involving Texas property and Texas equipment. I would argue to this court, there is no jurisdiction in the world with a greater interest in the outcome of this case than Texas. And I don't know how we can argue that the forum state is not the appropriate state when it comes to this particular case, especially when he can give his deposition by Zoom, he can travel. We're doing it today. I actually thought it was interesting because our client incurred damage based on a freeze, and here we are frozen and doing Zoom hearings today. I mean, it's oddly, unique to this case. But I would argue that there is interest in Texas, specifically when it comes to Texas property, majority Texas residents. The overwhelming number of witnesses in this case are out of Texas. They are our clients and their multiple employees. They are people who assess the damage who are all here in Texas. They are also the agent, Ryan Pike himself, is also located in Texas. And outside of Mr. Smith, we're unaware of any specific Texas, South Carolina person. I would also argue to this court, we would not get effective relief in South Carolina. And in fact, it would be judicially inefficient. Those are additional factors to consider when looking at federal due process protections. We would have to fly witnesses to South Carolina. It opens up two different cases about the same fact scenario. We could get conflicting outcomes in both cases. We could get an outcome in Texas that says Anchora is responsible and an outcome in South Carolina that says that Anchora is not. And we'd be talking about a South Carolina court trying to understand the Texas insurance code. It doesn't make sense that we would find effective relief in South Carolina. It doesn't make any judicial efficiency sense to transfer this case to South Carolina. And the shared interest of all the states is to police their own licensing, their own insurance licensing in their own case. And if there's such a violation, it should be litigated in that state. I'm almost out of time, so I want to answer any other questions anyone may have, but I just want to say, I think the trial court got this right. It's pretty clear that this case arises out of the specific contact, the specific license, and the specific profits that were made by Anchora between them and our client. They got this license to avoid the so-called draconian penalties and to avail themselves of the privileges of not having those penalties assessed against them. That's a protection. They knew this case was in Texas. They knew the property was in Texas. They knew the witnesses would be in Texas. They should know they could have gotten sued in Texas. That's all I have.
Any other questions? Thank you very much. Counsel for the appellant, you may proceed whenever you're ready.
Thank you. May it please the court, Catherine Gross for appellant. So I just want to address, I know there's been a lot talked about, specifically the payment by Texas Green Star related to all of this that was facilitated through us. I just want to touch on the IRA resource case again, because the court in that case specifically said that contracting with, even though we did not have a contract in this case, and accepting a fee from a Texas resident for services performed in another forum was insufficient to satisfy the minimum context test. So even if we had a contract and even if they paid us directly and it was not through the insurance companies, it would not be enough to satisfy the minimum context test. Also, the check that he was referring to, I think he noted it in the record. So that check was written pursuant to IPFS's direction, and that is in the record on 507 through 509. So if you look at that from IPFS, it specifically notates how much should be paid, why it should be that amount, and then it lists the numbers from the insurance companies who are dictating that amount. So all of that is coming directly from IPFS. It is not coming from.
We're really short on time, so I want to make sure I get a question answered. I'm still stuck on this point that Anchora seems to be saying, we just got that license so we wouldn't get fined. And the purpose of Texas establishing a license would be to regulate and ensure quality and protect Texans. Like that would be the basis for a government's ability to license. So for Anchora to say, I had no idea that by obtaining a license in Texas means that Texas might have some interest in regulating me and my conduct seems a little disingenuous. It seems like the existence of a license might put someone on notice that they have obligations in Texas. Can you respond to that more?
Yeah, of course. I think that, of course, the license was obtained, and I think it's really important to note that it was obtained for a client that was originally in South Carolina who moved to Texas. So that was the reason for it originally. But I do see your question. I think based on all the other interactions and how random, and specifically for the Texas Green Star, how, all of our communications took place in South Carolina. Everything that was done on our behalf was in South Carolina.
Okay, I'm just asking about when someone signs up for a Texas license, that might put it in their mind that Texas is regulating them, correct?
Correct.
And that they might have some obligations in Texas. So help me understand how we just got that license so we wouldn't get fined, is dispositive here and distinguishes this case.
I think just going back, it's distinguishable just because, again, what I was saying, that, all of our contacts with Texas Green Star were just they were not, I guess, close in the matter where getting the license would make us think like, oh, because someone reached out to us for this client in Texas, although we are in South Carolina. I don't think that it would be fair to automatically be like, well, you got that license, you're going to be subject to jurisdiction, even though all your contacts with them, it doesn't satisfy the minimum context test. It does not create general jurisdiction. So I don't believe that it would be fair to have that license just automatically subject you, even if, obviously you're doing it to make sure that you're complying with the law. Does that answer your question?
Anyone else have any questions? Okay. You can continue.
Still have a minute. You
Yeah.
continue if you want, Ms. Gross.
Yeah, thank you. All right. Yeah, and I just want to touch on, so the contractual relationship, I know that's been talked about a lot as well. Again, they dance around it. They say, oh, there was a contractual relationship, but it's never been specifically cited. They can't explain exactly where this contract is coming from, other than just generally, you were reached out to, you got this, helped us get this insurance. There's nothing there. I don't think that they've cited to anything, and I don't think what has been said means that there's a contractual relationship between these two parties.
Doesn't the check, isn't the check some evidence of an agreement between the parties?
So I guess the check would be more of an agreement between Texas Green Star and IPFS, in our view, because that check, again, IPFS is the premium finance company that the check was actually written to. So I think for them, that would be more of a contract relation between them, because they did sign off, Texas Green Star did sign the paper saying that that's how much they were supposed to be paying for these insurance policies.
I think I'm looking at the check on page 465 of the clerk's record.
Mhm.
And it appears to be Texas Green Star LLC paid to the order of Anchora Insurance Services LLC. Is this the wrong check?
No, that is the correct check. It's just it was facilitated through us. And I know that's confusing, but basically, again, we did not say, hey, you need to pay us this amount. They wanted IPFS to be involved. We reached out to IPFS for them. IPFS is the one that said, hey, this is the amount that needs to be paid. And then because of our involvement, that's why it was given to us to then kind of put down the line for IPFS.
Any other questions? I want to thank y'all very much for your capable argument and excellent briefing. And the case is submitted and it will be decided. Thank y'all.
Thank you, counsel.
Your honors.
Thank you.
Thank you, panel.